Good morning, good afternoon to everyone who's joining this session from all over the world, hopefully. And I'm here today, I'm Loretta Malintoppi at 39 Essex Chambers in Singapore. And I'm here today with Professor Alain Pellet, and who probably needs no introduction, but I shall say a few words just to recall that during his remarkable career, Alain Pellet has been, amongst other things, professor of public international law at Nanterre University, member of the International Law Commission, where he was also responsible for the report on reservations of treaties, a very important subject. He was president of the French Society of International Law and counsel and advocate in over 60 cases before the International Court of Justice, but also before interstate tribunals, and has been arbitrator in a number of disputes, investor-state disputes. In other words, Alain is an international lawyer in the fullest sense of the word. If I can start with a personal memory, I saw Alain in action for the first time in the Libya-Chad case before the International Court of Justice, where he was counsel for Chad, and I was the youngest member of the Libyan team. And I was in absolute awe of this very accomplished French advocate with his jeu de manche, his great presentation. Of course, I sat there thinking, oh my goodness, this is very impressive. And then since then, we worked together in cases and we worked against one another in other cases. In fact, I was, and you may remember, that I was with Alain in the first case where I pleaded before the International Court of Justice, Indonesia, Malaysia, where we both worked for Indonesia. And after my first pleading before the court, Alain sent a bunch of flowers to my room with a little note, welcome to the club. And I think that's a good start. Alain, do you still think that there is an exclusive club of international lawyers who plead before the International Court of Justice, before the World Court, and before interstate tribunals? Or has it changed since you started?
There is indeed not an exclusive, but I would say an invisible bar. I don't remember who wrote this article, maybe Charles.
Keith Hyatt. Is it Keith Hyatt?
Keith Hyatt, yes. Yeah. Keith Hyatt, with whom I had my first case. Not my first case, my first big international law case, but not before the court. He was, and I think there is an invisible bar, which is a fact, but I wouldn't say it is exclusive. And personally, I really always insist that young people be given a chance to show off before the ICJ or international tribunals. So I don't think it is exclusive. It is. We are criticized for that. They say that it is a small Malthusian club, that nobody can be admitted in it. But there is no admission. It is a problem for states to choose their counsel. But I must say also that states encourage this club to remain rather small, because they, vis-à-vis their public opinion, they wish to have kind of divas and be able to say to their public opinion, look, we have taken the best and the brightest, which is not always true. I think that the usual suspects are not unavoidably the best, and I think that young lawyers could be very much more excited by a case than we are, although I must say I am still excited. I still like that. I have still the pressure. And there is something else also. Interstates, it's a bit different. It is different for investment cases. But interstate cases are rare. And there is no room for hundreds of newcomers. So, of course, it is a bit an incestuous club. We know each other. I must say that among the judges sitting in the court, I am probably I would say friend, not only just like that, but rather good friend with maybe 10 of them. But this is unavoidable. We have the same formation. We meet in the same conferences. I sat in the ILC with several of them. I think what is important is just to behave correctly and not to confuse personal relationship with any kind of professional unacceptable relations.
But I think that's the way it should be, isn't it? I mean, the fact that your friends should not affect your independence when you're sitting as a judge or as an arbitrator. Of course, you're probably not going to be socializing during the case when you're appearing before that judge or that arbitrator. But I think, let's leave aside the situation of international arbitration, because that may be particular and very different. But when you appear before the judges of the court, obviously you're not going to go out to dinner with them unless there is another counsel for the other party that is appearing before the court. But it's the right way to go about it. I think I remember when my father was counsel for Spain in Barcelona traction, so a while ago, Judge Morelli was the Italian judge on the court. And we once met him in the street going back to the Peace Palace, and he changed. Not only didn't say hello to my father, but he changed sidewalk because he didn't want to have anything to do with us. Now, yeah. Of course, that what happened.
Well, I think it's more symbolic that even that is more symbolic that indispensable. You said it is what it should be, but I guarantee that it is what it is. I mean, for me, never any judge, even those with whom I am real friend, with whom we had in the past or even after they had become judges, vacations together, no judge has ever spoken with me of anything about my cases, at least when they were ongoing. When the judgment is given, sometimes we can joke about it, say, oh, you voted very badly in that case. But never I had any word with any of the judges on my case. So it is like that. I suppose that the judges behave like that with other counsel as well. So it is really an issue of personal state of mind, but hopefully we all have it. And yes. I don't see any possibility to avoid that it is a small mafia, as late Ian Brownie put it.
I never liked that expression.
Yeah, well, it doesn't.
As you can imagine.
Because you are Italian, but
exactly.
It's a joke, and it's okay.
I also joke to say the mafia does not exist. But anyways, but what I was thinking, imagine a situation like that in the context of international arbitration, and you sit in a tribunal as arbitrator, and a good friend of yours is counsel for one of the parties. Do you disclose that, your friendship?
Oh, yes, immediately.
Yeah.
But usually...
And has that happened to you before?
Oh, yes.
That type of situation? Well, have you been challenged as a result of your disclosure?
No, I was...
No, that's the thing. I mean, I think people are more...
Well, I was challenged from time to time as an legal expert. This is an absurd... practice in investment law, but I accept to do that, being provided I am independent and my client let me say what I want. But on this, I was sometimes cross-examined. Oh, but 10 years ago, you had a case with this law firm. I come out from I don't even know that this law firm existed. For me, it's another word. I must say on that I'm totally anti-investment practice.
You mean for the challenges against arbitrators or in general?
I think it is.
The challenge. Yeah. It's going too far, you think?
And I have in mind a recent case where I was asked to act as a legal expert. I was not 100% in agreement with my client, but they were generous. So, okay, you say the contract is that you say what you think, so go on. But then one of the QC, the other side, took, I think, half an hour to explain. Oh, but Professor Pellet was asked by the same firm 5 years ago to act as an arbitrator. He said, but and very genuinely, I said, I don't even know which firm retains me. If you remind me the case, I might tell you yes or no, but I cannot tell you what you are speaking about. And the president was impatient, not with me, but with the advocate. So they stopped, and after the breaks, they came back and said, "We forget all these questions."
He must have read the face
But
of the
I am
president.
telling you, I mean, for me it is ridiculous. When I swear that I will tell the truth, I tell the truth.
Yes, I know, but perhaps for one person like you, there are others who do not. So it's always good to have some rules in place that foresee that type of situation. That said, it's interesting. You said you sit as a legal, you appear as a legal expert in cases. So I imagine you've been expert in international law before investment tribunals, or on specific issues of international or public international law. I don't know, treaty interpretation or something like that. What do you think of that from the perspective of the tribunal? So in theory, at least, or in practice too, the members of an arbitral tribunal sitting in investment disputes should be experts of international law. So what do you think about parties retaining experts to brief or to lecture the members of the tribunal on subjects that they should know?
Well, I think
I mean, provocative intentionally for once.
not only the arbitrators must know something in international, whether public or not, but also the advocates. So for me, I must say I find it a bit ridiculous to call legal experts. Factual experts, I can understand, although I think they lie. But okay, you for evaluating damages, and I must say that as an arbitrator, for me, it's a worse thing because I don't feel really specialized in that, and it's terribly difficult to go through these cross expertise which say exactly what the clients want. So I don't trust experts, but at least you have two experts on each side, so you can try to make your way. But so for factual experts, unfortunately, I think they are unavoidable. But for legal experts, for me, it's a kind of mystery. And since I have started to be nominated as arbitrator, I have decided that I will never more act as counsel. There is an exception because I am counsel for a state because it's an old client, and I said, okay, I will make an exception for you, but I refuse to act as counsel. But I hesitated to. I am asked to be a legal expert. Honestly, I think every week. I don't take them. And anyway, my first question, my first warning is, well, you see, I would like to have a look at the file because I suppose you don't want that I say things which are totally different from your case. So I will act only prima facie. I sympathize with what you have in mind, but I will not accept to be censored. You will have to let me say what I want, and it will be my view and not your view. Quite often they say no. Well, maybe in half of the cases, we don't take the risk. I am happy with that. And when they take the risk, sometimes they try to influence me. And we have sometimes tense relations. But sometimes it goes very well. And I am not totally obtuse when they ask me to change a sentence, and I don't think it changed my global reasoning, I accept. But I am an independent legal expert. But I know some of my colleagues who sometimes say something, and in the next case, say the contrary, and I'm really outraged by that.
In that remaining and on the theme of experts, I remember that you have very strong views on evidence in international law. I recall reading something in particular you wrote, or an interview you gave about burden of proof and what burden of proof really is, and other notions of perhaps English law, such as estoppel. We talked about these things often, but in particular, I think you have strong views about witnesses and experts as well. You're not terribly fond of them, are you?
It is an understatement. I think it, well, first, I am absolutely convinced that 80% of them lie. They say what they are instructed to say.
You mean witnesses of fact?
Oh, fact and
or experts as well?
All experts. They are paid by the client, and they are ready to say usually what the client wants them to say. I think preparing experts is something outrageous. And sometimes when I act as a legal expert and I am said, we would have to have a short, they know me, so they are prudent to say, just some words, to prepare you. As I say, you will not prepare me. I am prepared. You can draw my attention to some points, but you will not prepare me. If it is that, the contract is off. But I think that, honestly, I'm afraid I am an exception. And that I think that experts and factual experts are the same. Preparing factual experts, for me, is just a scandal. And usually they do that. So I don't trust it. And my experience in the ICJ is usually that it was hopeless, useless. Once or twice on factual issues, I must say that I thought that when they said the contrary of their clients, they were trustable, but it's very rare. I don't think it's worth the time lost.
So I think all the parties that appear before you as arbitrator now are put on notice that you're going to pay no attention to experts.
Yeah, well, again, except maybe for evaluating the damage, because
right.
When you have both sides having opposite view, then you can try to make your way. But in a rather recent case where I chaired the tribunal, I insisted that I wanted that both experts team meet together and try to mitigate, to find a way out after we had decided on responsibility. And honestly, this was extremely helpful. They understood that we were a bit lost and that they had to explain. They could not agree, but on when they explained their disagreement, I think that the tribunal could make his way. So
yeah,
in this respect, I don't discourage possible parties to introduce experts in evaluations of damages, but on the facts. Let's say one thing in one side, the other in the other side, they are irreconcilable. Then
the problem is sometimes not only with quantum evaluation issues, but also with very technical issues. And the parties present their experts, and they often are at polar opposites. And it's very hard for the tribunal to come up with a solution which is not embracing one or the other's position or a compromise between the two. What do you think about the possibility of the tribunal appointing its own expert to decide on valuation issues, for instance?
Let me first react to your defense, saying, well, but there are technical issues, so it's good to have experts. I fully disagree with that. I think that what is important precisely when things are technical is that the council try to explain to, which are legal, try to explain to the tribunal, which is made of legal experts, how they see the thing. Just putting these technical experts before the tribunal doesn't help. It is for both parties to, I cannot find the word in English, faire le tri, and
to select,
to select
to
and
filter.
When they have understood, to transmit to the members of the tribunal what is their technical truth. But having these technicians, which are still technicians in front of me, usually is not helpful.
Well, I think it can. Sorry, go ahead.
Having the experts from the tribunal appointed is something else. I think it can be helpful, but I must say I hesitate to encourage this because experts are terribly expensive. And to add these tribunal experts to the parties appointed experts, I really hesitate.
Yes, no, I understand. And you need the agreement of the parties, and often the parties do not agree precisely for those reasons. One other possibility I suppose, would be to have a member of the tribunal who is an expert. So, for instance, if we're talking about a commercial case, you can have a construction, an engineer, an expert in construction cases, or you can have a quantum expert if valuation is an essential part of the case. Or, I mean, I'm thinking about the Kishanganda case. Of course, there was an expert sitting on that particular tribunal case between India and Pakistan, but that was because the original treaty, the Indus River Treaty, provided for one of the members of the tribunal to be an engineer. What do you think about that idea, to have an actual expert as an arbitrator?
I think that usually these cases are nevertheless legal. So I think that the last decision must really belong to legal to lawyers.
To the lawyers. No.
So I think having a technician to help the tribunal is okay, a neutral technician, but having him as a decision maker, I am not enthusiastic, I must say. It never happened in my cases, so I don't know.
Going back to, so you have the unique experience of having been professor of international law, an arbitrator, and counsel, and perhaps more often counsel than arbitrator, but you wore both hats. And wearing those hats, what do you think are the greatest qualities, would you say, in an advocate? And what are the worst flaws of an advocate?
The worst what?
Flaws, the worst defects of an advocate, and the best qualities.
That's a wide question. I think the most important, in these let's speak of big interstate cases. I'm not sure that it's exactly the same for investment cases. And I have no experience at all in commercial cases. I know that I am not good in commercial law, so I never take any commercial cases. But take in interstate cases, I think you always have big international teams. And the first quality is to listen to the others, to be able to understand that there are several, at least two main legal cultures, that the reasoning is different in common law and in civil law. And this, I know, sometimes it is debated, but in my experience, it is really a difference. And I think listening to the others, and even independently of that, usually these big teams are made of important or very able lawyers. And I think listening to one another is fundamental. This, I think, is the first thing. A second thing which is indispensable is really to go through the file, to know the details of the file, and not to concentrate on the part of the case which is your part. I think it's important to play collectively, and I mind what my colleagues say. I always read very carefully their drafts. I criticize them, and I'm very happy when they criticize mine, and they help me to get them better. I must say that my probably two best colleagues, they are dead, so I can give names, were Sir Arthur Watts and Sir Derek Bowett, and both were wonderful teamers because they just accepted to discuss, to be criticized. Even them, well, for me, they were quasi-gods, to be criticized for what they had in mind, and to help you, not to just criticize, but to say, well, look, you could do that. And sometimes I remember Derek Bowett, when I stuck to my point, he said, "Oh, Alain, are you going to say that?" When he said that, I thought maybe I should not. So I think this is something important. Again, and for the rest, I think it is important to maybe a third aspect also. It is important to listen to the client, but not to be, we say in French, a béni oui, not to say always yes to the client. It
Not
is
to be a yes man.
important to warn them, to tell them, look, this is a bad argument. And at the same time, to listen and to be open to their political demand. When there is a political strong view, you can always only tell them, well, look, okay, we can do that, but it will be damaging for the legal case. So you choose. And then it has happened to me to plead things which honestly I thought were not right, legally speaking, but just to try to take the best of a bad case. And this, I think, is the job of an advocate sometimes, since I am definitely a professor, maybe more than an advocate, whatever people think. Sometimes, and I write quite a lot, so sometimes it's easy to find in my writing things which are not exactly what I plead. And I think it is two different jobs. I never lie to my students. I don't lie never lie to the courts factually, but to the courts I just give the best or the least bad arguments, not always I am not a judge, and I think for the court, what is important is that the advocates give them all the possible arguments for their party, and then it is for the judges to make to choose what is the best or the least worst argument.
But I see now, luckily, there is a much wider group of people, including a number of people who grew up with you professionally and were your assistants in cases before the International Court of Justice, who are now flying with their own wings and appearing very successfully before the court and having wonderful careers. So that's terrific. And
I must say, maybe because of my professor orientation, this is probably one of my rare proudness. I am really proud to have helped these people. And when I am in a team, I insist to take young people. I think there must be a balance, not a team entirely made of newcomer would be rather stupid in the ICJ, where nevertheless the process is very special. But I really insist to take young people and to take real newcomers and not people. I think sometimes it is more successful than in others, but I'm really proud to see my former assistants becoming full counsel. And before when I see the advocates before the ICJ, I am happy when I see that more half of the teams are my former assistants or former pupils, honestly. This is, for me, real satisfaction.
It's a great legacy that you have. It's one of the best things that a professor can do, certainly. The other thing I wanted to ask you is I remember you wrote, or you had rather, an interview with James Crawford and Professor, I can't remember, it was Catherine Reggio.
Yeah.
And, and you were talking about pleading styles and advocacy from the common law system and the civil law system. And you had some great expressions to describe Anglo-Saxon pleaders, because of course it's a wide term that encompasses Americans, from people from the United States, as much as English QCs. And you were saying that English QCs are often impassive, and sort of less heated in the way they present their arguments. Do you still see that?
Yeah, it's not. I think it's not the main thing among Anglo-Saxon pleaders. There are quite different oral style, but on the substance, I still think that there are big difference between the approach of the case by Anglo-Saxons or common lawyers and civil lawyers. For example, after all, you are Latin, but you are British or American. The Brits are the worst for that for me. You are absolutely keen of discussing burden of proof, evidence, means of evidence. For me, this all is rubbish. What is important is to convince the judge. Each party must plead its own case. These and also these procedural incidents, which my British colleagues are sometimes so keen about, are for me totally stupid. I think this doesn't matter. What matters is the case, the legal aspects, the factual aspects, and these this proof is not admissible, does not really matter, and having hours discussing these kind of things is totally a nuisance.
Before we close, because we don't have a lot of time left, I wanted to ask you, what do you think about? There are a number now of websites or service providers that use artificial intelligence to conduct research, legal research, and sometimes also to look at arbitrators, their background, to do conflict checks, to verify if an arbitrator has sat with other individuals or if he or she has contacts with counsel, has had contacts with counsel. I'm thinking in particular of Jus Mundi, which is a very useful website, but there are others, of course. What do you think about using those kinds of sources to conduct legal research? And what about the use of, maybe it goes to be too far, the use of artificial intelligence or some kind of sort of technical data, big data in our profession?
Two different things. You evoked Jus Mundi. It happens that it has been created by one of my former students who was supposed to make a thesis under my supervision and who unfortunately left because he was very permissive in that. And before that, I was not using that, and I'm not sure my assistants used a lot these new tools. Since he created Jus Mundi, I use it, and I am absolutely amazed the time you win with that. With a caveat, I think you must check. It's not enough just to go through it and say, well, burden of proof, you have 100 of her, then you try to find new words. You must also go to the real judgment in order to see what is around the quote, and not to stick to what you find on Jus Mundi or other sites. So for that, it is a wonderful tool which must be used seriously. What on your other thing aspect, which you seem very excited about,
I'm not very excited.
that having knowing all about the I go back to my previous thing. I think this problem of conflict, more or less artificial, this encourage your the Anglo-Saxons council to go and try to find totally artificial reasons to recuse arbitrators, or you cannot recuse counsel. That's a good thing, but then.
Well, you can. I mean, there's been a precedent, at least in
Yeah, I
this
have seen that.
arbitration.
I think it is ridiculous because parties are free to appoint who they want.
Yes, but
I don't
they
agree with
can't
that.
do it if that. I mean, I think that decision was made because the information about counsel participating in the hearing was given at the 11th hour. So the position of the tribunal was that in that case, it affected the integrity of a properly constituted tribunal because this individual was a member of the same chambers as one of the members of the tribunal. So that was the reasoning behind that particular decision.
Yeah, every right is limited by abuse. So in exceptional cases, you can accept that. But I think it is for the parties to choose. So you cannot appoint a new council in order to make one of the members of the tribunal uncomfortable. This, I think, is
That's right.
a limit. But for the rest, it is. But so I'm afraid that these new tools, of which I have seen Mundi so excited about, I am excited because this I can look and say, oh, maybe I should disclose this, which I would never had in mind to disclose. But honestly, I think too much is too much, and on that we are and one small word on that. I think that the Brits are very hypocritical with the chambers when they say, oh, in chambers, there is no problem of conflicts. I think their barristers are conflicted exactly the same way as solicitors are. And I am really nervous about it, although I am not as nervous as they are about conflict. For me, conflict is something very real. Conflict is very rare, although I try to disclose everything. But since I am not very sensible to that, very genuinely, I might forget to disclose things which might, in Anglo-Saxons' views, should have been disclosed.
Yes, well, it's a complicated topic, as I don't know if you saw, there was a recent judgment of the UK Supreme Court precisely on the matter of disclosure. We won't get into that. I think with the remaining 4 minutes, Alain, I just wanted to ask you, any advice to youngsters who want to start a career as an international lawyer?
Well, first, he or she must like international.
Must be passionate.
It has to be a patient because it is difficult to succeed in that. Second, it is really time consuming. She must be a hard worker and not just do that from time to time, among other things. It is a full-time. And unfortunately, I must say, I am quite a feminist. And I must say that it is probably even more difficult for young ladies and for young men. Because the society is what it is. So it is terribly time consuming, and you must be ready to answer not night and day, but nearly so, and certainly day to day to your clients, to your colleagues. So hardworking. I also think that, as I said, you must be a good teamer. I think it is important to listen, to be ready, to be open-minded, to listen to the others. And a third point, I would really suggest that it is harmful to specialize too much and certainly too early. Maybe at a certain time of a career, you can become a specialist of international environmental law or international human rights. All young people love human rights, but I think it is very important to be, first of all, an international lawyer, and if possible, even not too much public international law. At least I have no problems with private international law. When I started my career, I wanted to be to walk on my two legs and to be both. And very quickly, I had to give up because it was too much. But I have tried until my advanced age. I have tried to be a general international lawyer. I have adapted very easily to investment law because there are a lot of public international law. You just maybe have to be open to the other aspects. But again, to young people, I say, try to be, first of all, a general international lawyer. It will be time to, if you have occasions to, and if you must, you will specialize, but better to have a wide view of what the international law is.
Thank you. That I think is absolutely hard to disagree with. Thank you so much, Alain. It was really fun to see you, and I hope to see you really in person before too long when the situation allows it, when we can travel again. It'll be a great day.
I don't miss traveling, but I miss you and my friends, of course. But
I'll be able to get out of Singapore soon. Thank you very much, and happy Christmas, and especially a wonderful New Year.
Same to you. Bye-bye.
Take care. Bye-bye. Bye-bye, everyone.